want to thank you guys for being here, and for taking the time um, to learn yourselves, right, and educate yourselves on various topics. And there is nothing better that you can continue to do but continue to learn. So hopefully the Alumni Network can serve as a bridge to continue that education, just how you were in high school at some level, right? Some have told me I wasn't too connected, but I want to be now. And some have said I was really connected and I want to stay connected. So whichever your story is, I hope this helps you grow. I want to talk very quickly about Top Golf. We have Top Golf going on tomorrow in Doral. It is an Alumni Network event. It began as an event for Women of Tomorrow with the community, but they have handed it over to the Alumni Network so that we could expand our footprint and continue to find our girls. So we're excited because all the profits and the fundraising is going to go toward the Alumni Network. And with that is all I wanted to say. I thank you again, and I will want to introduce you to Valerie Cambroni. She is going to take it from here and introduce herself.
Thank you so much, Anna. Hi, everyone. Really happy to be here with you all. Just quick background about me. My name is Valerie. Usually I go by Val, so feel free to call me Val. Now we're friends. I grew up in Miami, Florida. I was actually a Women of Tomorrow alum. Oh my God, I graduated high school almost 10 years ago. But I grew up in Miami. I know there's some Jamaicans here. My family's Haitian, so if there's any Haitian people here, well then, hello, ça passe to y'all. And I'll be talking to you guys a little bit about intellectual property law. So before we dive in, I want to know if anyone here even knows what intellectual property law is. And just a caveat, this presentation is very interactive. So I encourage you to please take your microphone off. And if you don't feel comfortable doing that, you can just put your answers in the chat. But yeah, does anyone know what intellectual property law is?
Nope. But I just a good guess is that it's from what teacher said before, it's basically like you have to make sure you copyright your stuff or ideas that you come up with.
That's a really, you're spot on. We're going to talk a little bit more about the different types later on, but I just wanted to get a good gauge of what the group's level is. So I love when people don't know what it is, because that means you're about to leave here with a ton of information. So, so just some quick background. Hold on. Okay, isn't this working? Okay, so who are we? Our organization is called Legally Black. I co-founded this organization along with Kiara Ortiz. When we were in law school in 2019, it was about the summer before our last year of law school, we had taken so many different intellectual property law classes, and we realized nobody knows what this is. Like, even some of our peers in our law school don't know what it is if they hadn't taken a class. And we realized how important it was and how important this information needed to go to minority groups specifically, since we are predominantly the people pushing the culture forward, but unfortunately not the same people that are in ownership of that. So, oh, she says we can't see your screen. Can you see the presentation, Anna? No? No, I don't know what happened. I'm just gonna share again. Sorry, everyone.
Sorry, guys. I got stuck here myself when I was replying. No, I cannot see the screen, but I froze as well.
Can we see it now?
Yes, now we can.
Okay, great. Let me just open the chat.
Thank you, Shakira.
Can everyone see it now? Because I want to be sure that if the chat's open, it doesn't mess it up.
Yes.
Yep. Okay, great. Thank you. So that's Kiara, the one I was just telling you guys about, who I founded the organization with. And like I said, our mission is to empower and educate minority communities on the value of intellectual property law. So basically, we saw a need and we're trying to fill it. So really happy to be here to talk to you guys. So what is IP? I believe it was Jamisha, is that, hope I'm pronouncing your name correctly, spoke up and says that it was, kind of like copyright and protecting different creations. That's a really good way to put it, to break it down in the simplest forms. Intellectual property law is creations of the mind that can be protected by law. I just realized I didn't say this, but I am a trademark attorney. I graduated law school in 2020 and now work as a trademark attorney living in Chicago. So no longer in Miami, but I'll be talking to you guys about the different types of IP. So there's trademark, copyright, patent, and right of publicity. They're all very, very different. And sometimes the words get interchanged all the time. And people say, oh, yeah, copyright that, when really they mean trademark. So if you leave with nothing at all today, I hope that you can at least just distinguish what is a trademark and what is copyright at the least, and what is a patent. We can do a little check-in at the end to see how far everyone is. But first, we're going to start with a little activity. Can you guess the brand? So this is the part of the presentation where I encourage you all to take your microphones off or to please use the chat feature. Name that brand.
Nike.
Nike.
Yep. You guys are quick with it. Okay, moving on.
Telfar.
Telfar, that's right. And the creator is Telfar Clemens.
Hershey.
What's the full name?
Hershey.
Hershey's chocolate. Hershey's
Hershey what?
Kisses, yeah.
Hershey's Kiss. Yep, Hershey. Actually, Hershey Kiss, not Kisses. Oh,
Okay.
well, it's interesting, which we'll talk a little bit about how one brand can have multiple marks. But yes, Hershey Kiss and Hershey Kisses, keep that in mind. And Hershey, keep that in mind as well. How about this one?
Louis.
Louis.
Louis. That's correct.
Christian Louboutin.
Yep, Christian Louboutin. And last one.
Marc Jacobs.
Yep, it's a really popular bag right now.
My sister
Marc
loves
Jacobs.
those bags.
Yeah, they are super duper popular. But some people just call it the tote bag and don't actually know who makes it. So I'm really happy and impressed that you knew the name. Okay, so let's talk a little bit more about how you were able to guess the brand. What stood out to you?
It's the logos. For some of
Logos, What else?
Pattern.
patterns. How about shape or color?
Yeah, color.
Right? Shape, color, logos, designs. So these are all really important concepts to keep in mind when we talk about intellectual property law as a whole. So we'll probably be looking at brands a little bit differently after this presentation. But to get into our very first type of IP law, the first we'll discuss is trademark. So a trademark is generally a word, phrase, symbol, or design, or a combination of those things that identifies and distinguishes the source of goods from one party from the other, right? So a trademark, keep in mind, it only protects a word, phrase, symbol, or design. And the design part of that is very specific, which we're not going to touch on too much because it gets kind of confusing, but word, phrase, symbol. Now, the purpose of a trademark is to protect consumers from confusion. Imagine you were in Publix and you're going down a candy aisle and all of the candies were the same exact color. Do you think that you'd be able to recognize which is a Skittles bag and which is a Twix bag? Probably not. So the fact that every single candy brand, even though they are owned by like the same person, all have different colors and distinction in the shape of the candy themselves, the name of the candy, the color of the branding of the bag of the candy, all of that goes in. And the purpose of it is not just to create a distinguishable brand, but to help a consumer not be confused as to what they're eating. Because do you think, imagine this, if another candy brand came out with a triangular shaped type of milk chocolate and then put aluminum foil around it, and in the inside of this piece of chocolate there's like guava or like something that doesn't really go with chocolate. Maybe some people might like guava and chocolate, but let's just say that was the case, right? And let's say Hershey's was like, we don't want to be associated with a candy company that's putting guava in their chocolate because that's not something that we do. But the branding of that other company is so similar that a consumer might think, oh, Hershey makes this chocolate too. So Hershey and a bazillion other types of brands put so much money in their marketing and advertising and branding and packaging for that mere reason, so that a consumer knows for a fact that it's their brand that created this chocolate. And this is also what gives them the means to go after those companies that do things that are similar, which we'll talk a little bit more about the enforcement side of IP. But who regulates trademarks? There is a large office in Alexandria, Virginia. It's called the United States Patent and Trademark Office, and that is who regulates trademarks in this country. So if you were to file a trademark application to protect your business, let's say that's the name of your business, the slogan of your business, or a particular design element of whatever product you're offering, you would file the application at the United States Patent and Trademark Office, and you would hire someone like me to do that for you. So the rights that you obtain with trademark protection are actually really awesome. You get the exclusive right to use the mark in connection with the goods or services listed in the registration. This part is really important. Some people think that if you get, someone asked a question, can nonprofits trademark their names or logos? They absolutely can. So your business entity doesn't matter. So Legally Black, which we are a nonprofit, is trademarked.
Women of Tomorrow is trademarked.
Yes, Women of Tomorrow is trademarked. So one really important thing though, and concept to understand is that when you get a trademark, you do not get blanket protection for anything, right? Hershey's, when they file their applications, they have protection for chocolate, candy, right? They file in the specific class for candy, which is usually a number, right? There are like 45 classes, I want to say. And then each class is a number, and then you file your application in the particular number. And you have to prove, unless you're doing an intent to use application, which we won't get into that, you have to prove the use, right? So you can't just like file for like 30 classes, because then the USPTO is going to be like, okay, show us a picture of every single way that you are using this mark in those particular classes. So the reason why the distinction is important is because once you get a trademark, it doesn't mean that you get to use it for everything, right? A perfect example of why we have classes at all. When you go to Publix, I'm going to keep using Publix. Dove chocolate and Dove soap are doing what with the brand name? What comes to mind when you think of Dove soap? You probably are thinking that it's like soft, right? That the soap is soft and, you know, makes your skin feel good. What do you think of when you think of Dove chocolate? Probably the same thing, that the candy is soft, right? They're both using the concept of this particular bird to kind of evoke the same thing, but it's not the same type of product. And that's why they both can have trademark registrations for the word Dove, but they have it in different classes, right? Because Dove soap is going to have it for soap, lotion, deodorant, all the other different types of goods that they make. And then Dove chocolate will have it for the candy, and maybe they make food as well, who knows? So it's really important because that allows different types of businesses to exist in the marketplace with similar names, as long as they are not doing the same thing. Because a consumer won't be confused, because you're not going to find Dove chocolate next to Dove soap. The store doesn't even organize the things that way. So then the next really great thing is that you can use the R symbol. So people like to think that if you see this R symbol, it means that you have a copyright, but actually that means you have a registered trademark. It has nothing to do with copyright at all. And then finally, the most important thing of having a trademark registration is that having the registration allows you to bring an action in court. You can sue somebody if you have a registration. You cannot sue somebody if you don't. So if your business, you find out that someone is using the same name for your business, doing the exact same thing, and you don't have a registration, you won't be able to send them a cease and desist letter. You won't be able to threaten them with a lawsuit because you don't have the registration. So when you file the trademark registration and the USPTO accepts it, then that basically means that in the United States, you have protection nationwide for your mark in the particular classes. So here's an example. Let me move this over. So this is the Fenty Beauty by Rihanna trademark. I know it's very boring. It doesn't look great at all, but you can see it's registered in class 3 under goods and services for makeup, cosmetics, cosmetic kits, comprised of makeup, lipstick, lip gloss, eyeshadow, concealer, foundation. When you file your application, you also have to write when your first use was, basically like when you started using this. So even if you have a business in existence right now and it's been existing for, let's say, 10 years and you never filed a trademark, when you do file your application, your attorney is going to put the very first date that you marketed your product or services to the public, which will be that date from 10 years ago. So you're going to get protection as of the priority of then, and not when you just file it today, let's say, which is really great for you, because if another mark comes up and they have only been in existence the last 3 or 4 years, you have priority over that. Okay, then here you can see the attorney, you can see who the owner of it is, registration date. We won't get into some of these other specifics, but this is what it looks like. And like I said, let's talk about this distinction really quick. TM does not mean you have a registration. It means that you intend to, you're basically, when you see TM at the end of something, either the brand has applied for a trademark and they haven't gotten it yet, so they're still in the application process, which can take up to a year or longer. The PTO is very backed up right now. Or it could mean that they are just trying to distinguish themselves, but it does not mean that they have the trademark. The R symbol is the only symbol that means you have a registered trademark. Okay, before I move on, are there any questions?
Questions, yes, Valerie. So why is it good to say that you have a TM? Like, isn't that like opening yourself up to telling people you're not registered?
No, it is good to say because it's basically showing the consumers and the public that you are intending to distinguish yourself from other brands and that you have the intent to proceed with the trademark process down the line. So if you have a business right now and don't have a registered trademark, you can put the TM on it. And when you do get the registered trademark, then you can put the R symbol.
Understood.
So it's definitely beneficial, but not a requirement. So if you're not doing it and still apply, you can still get the R symbol. Okay, we are moving on to copyright law now. So copyright law is typically what people, that's probably the word you've heard more than you have trademark or patent or some of the other types of IP. But to be specific, a copyright only protects. So just to quickly recap, a trademark will protect a word, symbol. What is the directory link where we can search for trademark names? So you can go to the USPTO website, which I can send this to Anna afterward if she wants to send a follow-up, but go to USPTO and then on USPTO, I believe there's like a link somewhere at the top that says trademark. If you hit the drop down, it should say like search for trademarks. And that's like TESS is the name of the system where you can search for trademarks. That being said, there are many different types of searches. So you can search the USPTO database to see, but that doesn't necessarily, if you don't know what you're doing, which is why it's really important to hire a trademark attorney to help you with this, though the USPTO does have a lot of free resources and videos, so you probably could get a pretty good overview from just watching that. But there are different types of searches that a business might conduct. Some are more comprehensive and some are simpler. And that's, I won't get into the weeds too much of that, but it is a good source for you to just check quickly if your business name is already registered. But pay attention to the classes because if it's not in what you're doing, then it may not matter. Okay. Oh, I guess I didn't say this part, but if there is a brand name that is already registered in your exact class, it is likely going to be an issue for you to get the registration. So you cannot, there are not multiple, let's say, Dove chocolates, right? There's only one Dove chocolate registration. All right, moving on to copyright. So copyright protects books, songs, movies, paintings, sculptures, computer software, anything that qualifies as a work, right? And copyright protection is really different from trademark protection because one, of the type of thing that it protects, and two, how long it lasts. So another thing that's important about copyright, you cannot protect an idea. You can only protect the expression of an idea. Meaning if you have an idea for a song and you don't do anything with it, and it just stays in your head, you don't have a copyright in that song. You need to actually go and either write the lyrics down or record the song. And now you can get copyright protection in either the lyrics as a songwriting protection, or you can get the recording protected. So what do copyright owners have? If you get a registered copyright, which copyright law is a bit different than trademark in that you already have a copyright the minute you've created something. What you don't have is a registered copyright. So someone who creates something but doesn't file that with the Library of Congress, which I'll talk about later, it's a bit confusing. You cannot enforce your rights the same way you could if you had the registered copyright, but you still have a copyright in it. So someone cannot copy what you're doing. If you do have registered copyright, however, you can reproduce the work, prepare derivative works. A derivative work would be like a remix, pretty much, right? So like if you have a song and then somebody else remixes that song, that is a derivative work of your song. So you can get protection for the remix as well as the original song. You also get the right to distribute copies of the work and perform and display the work publicly. The copyright is really cool because it lasts much longer than a trademark does. So a trademark can last a long time as well, but you have to consistently renew your registration after like 5 to 7 years. You have to just keep renewing it. With a copyright, the minute you file it and you are granted the registered copyright, it lasts for your entire life plus 70 years, which is why you'll hear things like, oh, something has been released into the public domain. It basically means that the author died and 70 years have passed, and now this is in the public domain. So you'll hear a lot about like Walt Disney stuff is coming back into the public domain. That's because that time period has expired. And there are a lot of free resources. So if you guys are building a website, let's say for your business, or you want to use things to put on your social media and you're kind of cautious or worried that you might be using somebody else's images, there are databases. If you just type in like public domain photos, there are plenty of websites that have compiled a bunch of photos that no longer have copyright protection on them, and you're free to use that in whatever way that you want. So that's a good way to, you know, potentially protect your business if you are trying to use like, you know, like if you just need a picture of like kids playing or something, right? You can go on this website and find a picture of kids playing that's released in the public domain that won't open you up to any potential lawsuits. So the entity that manages copyrights is the Library of Congress. So the United States Patent and Trademark Office does trademarks and patent, like the name says, and copyright is managed under the Library of Congress, which is also in Washington, D.C., which is about like 40 minutes from Alexandria. I used to live in D.C. and I went to law school there, so I'm really familiar with the area. The Library of Congress is a really great place to visit too, if you are interested in learning about American history at all. So this is a symbol that you guys are probably really familiar with. This is the copyright symbol. So if you see this on something, that means that this has a registered copyright, which again, you'll only see it on something that is a work. So this could be a play, a choreography can get copyright protection, movies, TV shows, music, poetry, anything that's an expression of an idea and is actually one of the listed things within the law that qualifies as a work. All right, any questions before I move on about copyright law? Okay, so copyright in music. The reason I made this a whole nother slide is because there are attorneys who strictly practice music licensing law, because that's how massive of an industry it is and how like insane it is. The copyright world as it relates to music, it's just so big and it breaks down into so many things. Especially because when you think about a song already breaks down into multiple areas. So there's that composition of the song itself, right? Which could be the production, like the beat, right? Which could have been made by a producer. And then there's also the recording of the song. And then let's say the song has lyrics, right? Then there could be a songwriter. That could be 3 different people on one work. So when you think about the breakdown of the money of how that works, this is why you need attorneys to do just this part, because when we're living in a royalties streaming music world right now, and the way that artists are compensated also depends on who is part of the work itself, right? So if you're Taylor Swift and you write and produce all your songs, you're probably making a lot more money than someone who is hiring songwriters, finding producers, and then all they're doing is recording their voice on top of the beat with the songwriter's lyrics. Okay, we're moving on to patent law. So patent law is really cool. I'm just going to start by talking about the iPhone. This is like one of the best, I think, examples to really break down how cool patent law is. I know my screen is blurred, but everyone has, I don't know if you all have an iPhone, but you're probably familiar with an iPhone even if you don't. So the iPhone has over 100 patents on it alone. So a patent is an exclusive right granted by the government for an invention. So this is the area of law that would protect your invention. Now, the thing with the patent and invention is that it needs to be novel. You cannot get a patent for something that already exists, right? You cannot get a patent for a water bottle. The only way you could get a patent is if you create an invention that's an improvement, a new improvement on the water bottle, let's say. So the patent does not last as long as a copyright does. You only get it for 20 years. And the reason why that's important is because patent is the body of intellectual property law that protects medication. If we allowed, like from a policy perspective, if we allowed a pharmaceutical company to have protection for a medication for longer than 20 years, what would happen? Nobody would gain access to it. So this is why when you go to CVS or Walgreens, whatever, you will see the generic version of really popular drugs, right? Like Advil has the ibuprofen generic version right next to it. So Advil used to have a patent on it, the composition of that drug, and now it doesn't. And that's why you can buy the generic version of it. Like I said, the United States Patent and Trademark Office is the body that regulates patents. So there's two types of patents, which I think we'll go back to the iPhone for this. So a utility patent protects the way that you do something on the invention, and a design patent protects the design of the invention itself. So a good example of utility patent is, you know how you have to use your thumb and this finger to zoom in on the iPhone to see something? Apple has a utility patent on the mechanism of doing that, because that's a way that you do something, right? Then they have a design patent on like the way that all the apps are arranged on the phone. They have a design patent on that. They also have utility patents on the way that you screenshot on the phone, right? That's a certain way that the utility of the way the phone works. So yeah, these are the two different types of patents that you could get. You also will find design patents for really popular shoes, which I'll show you guys in the next slide. So like Yeezy has a design patent on the slide itself. And then the last type of plant patent is a plant patent, which we won't talk about too much, but if you discover a new plant, then you can get a plant patent on that and protect the plant that you've discovered. So here's that image I told you guys about. So this is actually a really old iPhone because it still has the button, but this is the design patent mock-ups that they protected. So it's basically every part of the phone itself, right? Like that top part, the circle, the big screen shape. This is actually really cool. And for like IP nerds and stuff, there was a Samsung and Apple lawsuit that lasted 10 plus years. And in the end, they ended up settling. But basically, Apple sued Samsung for what they believe stealing their design and creating all of their phones to subsequently look like the iPhone. Because about 15 years ago, nobody's phone was just this like one screen design. But ever since the iPhone came out, now Android's every single phone is just a one screen design. So it was a really long lawsuit. And then in this other picture here, you can see the Yeezy slide. You can see the applicant is Kanye West. The assignee is probably the company that created it or helped him create it, the term 15 years. And you can see that they protected the design and the shape of the shoe. This is actually kind of revolutionary, only because it's very hard for fashion designers to get protection for anything that they create, because you cannot get protection for your t-shirt, or you can't get a patent for a t-shirt because it's not new, right? But this slide was he was able to get protection for it. Okay, so the very last type of IP we'll talk about is right of publicity. This is a really cool one that you guys probably also know about, but I think it's incredibly important. And we'll just try to play this video to try to illustrate why that is. Can you guys see the screen? Okay.
We actually think about 80% of our shoes, South Korea, Taiwan, and I know I should be ambivalent about that, but I'm not now. The judge in the divorce, she just gave me something.
Sorry, guys, I'm gonna fast forward a bit.
But she's 7. She wants to fill money and make them in. Taking us all. I mean, if we're gonna make it, we gotta take risks. Now when I'm a 7-year-old on something after. I'm sorry. All right. I do see. That's just a shoe. No. The shoe was only just a shoe. Hey.
Okay, so I'm gonna pause right there. That's actually a clip from, sorry. Can I go back to further? Oh, here it is. That's a clip from the movie Air, which talks about Michael Jordan and his whole entire success with the Jordan and working with Nike at the time, who was a very no-name brand. The reason that's so important, that line, a shoe is just a shoe until someone steps in it, is because it basically demonstrates how valuable someone's likeness can be, and how valuable that could be to a company, and how valuable that can be to a brand. So right of publicity is the body of intellectual property law that will protect an individual's name, image, and likeness, or other recognizable aspects of one's persona. So essentially in the movie and what happened in history, Nike gives Michael Jordan this like crazy deal to design a shoe around him. But his mother, played by Viola Davis in the movie, is basically negotiates a deal that he's going to get a percentage of every single shoe made, which at the time nobody had done that. But his mom in the video and in the clip says that essentially for the shoe to be successful, Michael has to be successful. So the Michael Jordan that we know, the amazing basketball player, ends up creating this popular shoe, but that was only because he was so great. So now just for context, to this day, he still gets 400 million plus from the Jordan brand every single year because of that negotiation with his name, image, and likeness. So basically everyone has the right to control the commercial use of their name, image, or likeness, but by the name of it itself, it's mostly exercised by public figures. Another really popular example, Kim Kardashian, about a few years ago, sued Missguided. I don't know if you guys are familiar with that, but it's a fast fashion brand. She sued the brand because they started using models that looked a lot like her, and they were selling clothes that looked a lot like the Yeezy brand clothes. This is back when Kim was wearing, like, she probably still is, but like, what Skims essentially looks like now, and her husband was a co-creator and helper on that brand as well. But Kim was successful in suing Missguided because she was able to show that they were using models that looked like her image, right? Large butt, long black hair, same skin color, everything about the models was just like basically a Kim dupe. So it's really important to protect your name, image, and likeness, because essentially another brand is profiting off of your own persona and you're not getting paid. So is there a federal right of publicity law? No. So all the other types of IP that we talked about are federal. You get federal protection when you get a copyright, a patent, or a trademark. Right of publicity is not. It's state by state. And one of the most popular states that has some of the best laws for right of publicity is California, which not surprising given that Hollywood is in California. So this is actually really cool and has kind of a big deal for anyone who's in sports. I know you talked about your daughter being a gymnast, but recently the NCAA adopted its NIL policy for the first time ever, where athletes can now get paid for any sponsorships that they're doing, which is pretty revolutionary. It wasn't happening before, but I'm sure you can imagine how popular college basketball is, college football is. And to think that before this, none of those athletes were getting paid and the school is consistently profiting off of their name, image, and likeness. So this is something that's still in development in a lot of states. It's kind of a state-by-state policy right now, but hopefully we'll see some progressive legislation on this in the future. Okay, so just to recap, we're going to do a little Q&A, true and false. Feel free to shout the answer out or to type it in the chat. True or false? If I register a trademark for my brand name or logo, I can prevent someone else from registering the same name or logo, even if it is associated with different goods or services.
True.
False. Yep. False. I see two falses. Okay, anyone else? False. Wendy said false. Congrats. You guys are right. The answer is false. A trademark registration can only be obtained in the specific class or classes that your goods or services are used or sold. Just because you have a trademark doesn't mean you own a monopoly in that symbol, logo, or name. I can only use TM when I have a registered trademark. False. Anyone else? False.
False.
Yep. The answer is false. Anyone can use a TM symbol regardless of whether their mark has been successfully registered or applied for. Even if a trademark application is rejected, an owner can continue to use the TM symbol. Okay, copyright protection lasts forever as long as you continue to promote your work. False. False?
False.
Yep, you guys are really on it. Awesome. Okay, false. Copyright protection lasts for the life of the author plus an additional 70 years. After that, the copyright protected work falls into the public domain. You cannot have both a design patent and a utility patent on one invention. True or false?
False.
Yep, you guys are on the money again. You can have both a design patent and utility patent if you want to protect both the design of the invention as well as its functional properties. And last one, you cannot simultaneously obtain a patent and keep your invention a secret. I actually didn't really talk about this, so no worries if you don't get this one right. So the answer is true. You have to disclose your invention in your patent application, and the details of your invention will be made available to the public. And actually, in some countries, if you are already selling your invention before getting patent protection for it, you'll be ineligible to get patent protection. So if you invent something, find a patent attorney immediately. Figure out if you can get it patented and move forward with that process. Because if you put it out into the public, you're basically saying anybody can copy this. And it can really hurt your chances of getting the patent protection, which can be so valuable. Another amazing part about IP and why we want to promote that people know what this is and that they protect the things that they create is because you can license all of your IP. So when you think about IP, like just the breakdown of the word itself, intellectual property, think about your house, right? You can rent your house out once you buy it. If you go buy a commercial real estate building and you want to start renting out units in your commercial real estate building, you can do that. You can do the same thing with your IP. So if you have a trademark, or a patent, let's say, you can license that creation to anybody who wants to use it, and they have to pay you to use that for the duration that you have that protection. So it's really valuable. You know, if you're selling your business, you sell the IP with it, which also can be really valuable. Imagine you have a business that created a really popular product, right? And you own the trademark to the name of that product. And the name of that product is what's making the product so popular. Let's say someone wants to buy it. Now they have to buy the registration from you as well, which you can, price at whatever you want. So it's all really valuable to have IP and to know how you can use it to your benefit. So yeah, you guys can follow us on Instagram. We also have a website, which I'll type here if you are interested in learning more about Legally Black, what we do, or we post a bunch of like IP tips. We have like a quiz time on the story and stuff. So it gets like more into the weeds.
I have a question for you guys. So, I don't know, I saw this on TikTok, but you know how they said like when you sign your name, you could put TM by your name? Like, could you explain further like the logistics behind that? Or
So
is it not right?
yeah, so typically it's not easy to get protection for your name generally. Like it's like it'll be difficult to get trademark protection for your name. Putting TM by your name, if you don't have an intention to try to trademark your name, doesn't really make any sense. I'd have to see the context of how they're using it. Is their name like what they're also using to advertise services or products as
I
well?
think it's like to protect it from like okay, I guess using an example would be better, but for instance, like you go to buy a car, you sign, but you don't want them to run your credit with so many people. So you put TM as a way to prevent them from doing it. So it's almost like if you don't get my permission to do it, you can't do it. That's the example I think they had used based on my memory.
Yeah, no, I'm not familiar with that. What I will say though is if you are producing content, put the watermark of your ad name or whatever the platform is on the videos, which I see people do all the time, and it's good because people steal from social media all the time. So if the watermark is on whatever video or whatever you created, then if people do copy it, they'll have to copy the watermark anyway, and everybody will know the source of where that came from. So another, I think, kind of a cool concept that's come up now is a lot of people, social media, like people are like warriors, right? Like they'll get on somebody who's copying somebody else, which can be really helpful for the person who's trying to protect whatever it is. If you can rally people on the internet to support you and kind of like tell the other person or the bigger company to stop being a bully, let's say, that can get that company to stop doing it because now they're getting bad publicity and they look bad. So these are all kind of strategies that IP attorneys might use or that you can use individually without having to work with an attorney if you find yourself in the position that a larger business is stealing from you. Any other questions?
Okay, thank you.
Wendy has a question. I don't think you're muted, Wendy. It doesn't look like it anyway.
Oh, this question
Sorry?
for this.
You're muted, Renee.
Yeah, I was asking if the recording would be sent to us for this session.
I'm not sending it, but what we're gonna do is we're creating a library of events, and this is gonna be part of it. It's in the works, Renee, but it will be available at some point
Okay.
as we get to it. But sooner than later,
Uh,
to be honest, it's gonna be available probably within the next 60 days.
Okay, thank you.
Wendy, okay, my question is whether patent protection applies internationally. Okay, so everything we just discussed is US law. However, you can imagine businesses like Zara, right? You can go to Zara in Turkey, you can go to Zara in Paris, you can go to Zara in you're all over Europe, all over the world, right? There are stores that are all over, businesses that are international. You have to get IP protection in every single country. So every single country has their own patent and trademark office, their own copyright office. So all of what we discussed is just US based protection. If you are trying to sell products or advertise a business that runs internationally, and let's say there's a particular area or particular country that you sell in that your product is really popular in, you might want to consider protecting it in that country as well. Because if somebody else in that country gets protection before you do, then you're kind of SOL. So definitely, this is why it's really important to get an attorney if you start getting to that level, though, because it's a lot to manage. You know, every single jurisdiction is totally different than the other. And also, like, so when your brand gets really big, it's kind of like a fun fact, when Apple was coming out with the Apple Watch, they trademarked the Apple Watch in Jamaica before they did it in the United States, because you can file something called an intent to use trademark application. So an intent to use application, there's two types of applications, intent to use and in use. An in-use application means you're already marketing and selling the goods or services. An intent to use means you have a business idea and you haven't started doing anything yet, but you intend to do so in the future. With that type of application, you don't have to show proof of use. So you don't have to show any pictures of the product or the business or anything. You just file to protect the name in advance. And then during the process, after you get a notice of allowance, then the USPTO will give you 6 months to start showing proof of that use. And if you're not ready in 6 months, you can keep extending that like 5 times. So you can get a couple of years really. But the whole time you'll have already had protection for the name, which is important, right? Because if you're trying to launch something and you don't want people to be able to take the name from you after you've already made it public, you want to do this in advance. So a lot of businesses, if you want to see what's coming out or what a business is doing, you can go check the USPTO and see if they've already filed intent to use applications, because you can expect that it's going to come out in the future, or that they're in the works of doing it now. So the reason I mentioned the Jamaica thing, though, is because Jamaica's not as popular of a jurisdiction to file your trademark in, and nobody was really going to pay attention to what Apple was doing in Jamaica. So they did that there first before they did it in the US as a way to, because I mean, think about how many products, if you go on Amazon right now, you can find a bunch of like fake looking Apple Watches. So but these businesses get like really strategic. I was about to ask that working in the medical device industry. Yeah, I'm sure medical device. I think with medical devices that they're probably looking at patents, and you need to have been filing the patent well before you put that out in the public. Trademarks are a bit different. You can do the intent to use route, or you can do it the in use route, like I said. But if you have an invention, yeah, you need to talk to a patent attorney yesterday. No problem, Wendy. You guys have been a joy to talk to. I love how engaging you all were. Really appreciate it. This is like so much fun for me. I'm such a nerd about this. And I think that everybody needs to know what it is because it's so important. Like after this conversation, you're probably gonna go to the store and start looking around to see if you see the C mark or the R mark, or you know, there's a lot of like news in the fashion law, if you're interested at all, talks a lot about really cool lawsuits between big fashion companies. There's a website called IP Watchdog, a lot of other cool lawsuits you could read about that are all related to IP issues.
Thank you, Valerie. This was so great. I think everybody has the same feeling. We walked out of here learned with so much information. I know I did. I got a couple wrong answers. I know you guys heard that. Um, but no, I just want to thank you so much. This was really, really great. Everyone, stay tuned because next month we will have another virtual session. And I would love for you to join. Also, if you want to hear a specific topic, let me know what that is. You know, it's my job to go find speakers that you find valuable. So let me know what you want to hear. My email is, yes, it's formal, but it's not formal. Please use it to communicate with me as often as you want to. One more thing, on Top Golf, there are 2 free tickets. We had a sponsor who donated a bay, and we have 2 free tickets. So if you want to attend Top Golf on Thursday, that's tomorrow, right? That's tomorrow, yes. At 6 p.m., let me know. The only thing that I ask is that if you do take the ticket, attend. Okay. So please let me know, email me, and I will hold a ticket for you guys. It's between 6 and 9, and it's casual. You get to have fun. There's food, and you know, get to play golf, and you do not need to know how to play golf. It's like fun golf. I don't know how to call fun golf, but like putt kind of, but not really, just further out. And that's it. Thank you guys again.
Oh,
and
Anna,
tell me.
I know everyone's cameras are off, so like no pressure at all, but can we take a picture?
Yeah.
There's a tease. I'll literally do it on my phone really fast. If you don't want to take your camera off in the picture, it's okay. We just have to document this for our own stuff. All right, so I'm just gonna smile. Wait, let me zoom in a bit more. Okay, 3, 2, 1. All right, it'll just if anyone's uncomfortable with their name being
Please.
if anyone's uncomfortable with their name being shown, I can block them out. Just let me know.
I'm good.
Okay.
In here. Thank you again, Valerie. Thank you, everybody.
Bye,
Have a good
everyone.
night.
Thank you so much, Valerie. Very, very good presentation.
Thank you. Bye, guys.
Bye.